Indictment means a charge of a felony voted by a grand jury based upon a proposed charge, witnesses' testimony, and other evidence presented by the public prosecutor. To bring an indictment, the grand jury will not find guilt, but only the probability that a crime was committed, that the accused person did it, and that he/she should be tried. District attorneys often only introduce key facts sufficient to show the probability, both to save time and to avoid revealing all the evidence. While grand juries are common in charging federal crimes, many states use grand juries sparingly and use the criminal complaint, followed by a preliminary hearing held by a lower court judge or other magistrate, who will determine whether or not the prosecutor has presented sufficient evidence that the accused has committed a felony. If the judge finds there is enough evidence, he/she will order the case sent to the appropriate court for trial.